Right, good morning all. Sorry about the confusion earlier on. The aim of the session is to go through part 2 of the Occupiers Liability Act 1984. I've not set any work yet, but once I've gone through part 2, which is really not difficult at all to understand because it's very similar to the first part that you've already completed, but once I've gone through that, then probably next week I'll set you some work on part 2 of the Occupiers Liability Act 1984. Right, so all I'm going to do is just quickly go through the slides just to remind you of some of the key facts that you need to remember. Right, so first one, the key legal authority that allows persons injured on somebody else's land is the Occupiers Liability Act 1984. It's a lot more generous because it allows trespassers. A trespasser is somebody who goes onto somebody else's land without permission. So the law is very generous in that it allows them to claim some form of compensation. You do have to remember though that the old position was that if you were a trespasser, you couldn't claim any compensation. That point, as in the fact that you couldn't claim any compensation, is confirmed in the case of Adian Dumbrek, where a 4-year-old lad was injured when he fell through an unprotected cover on a colliery land. So the key principle is to remember that Adian Dumbrek goes with the fact that you couldn't before claim compensation as a trespasser. That has now changed by reason of the Occupiers Liability Act 1984. Do remember though that some of the key words that you identified in the 1957 Act will still apply to the 1984 Act. So in other words, the meaning of occupier, which is not defined in any statute, you need that same meaning for the 1984 Act, and the same applies to premises, which is again not defined in any Act of Parliament, but whatever you learned from the 1957 Act will apply to the 1984 Act. Okay, so that's that point. Now, the next point, now on the slide that you've got, which is the second slide after the first slide, do remember that the actual case that you need to refer to is not Adian Dumbrek, it's Harrington, British Railway and Harrington. So do remember that particular point. So practice statement of 1966, and we've not done this yet, we'll have a look at judicial precedents later on, but practice statement simply is a legal authority that allows the House of Lords to change their mind if they've already made a decision about a previous case. And judicial precedence is all about following what's been decided by courts above you before. So the House of Lords, under the practice statement of 1966, allows them to move away from any decision that they might have taken previously. So in 1929, Adian Dumbrek clearly stated that as a trespasser you couldn't claim compensation, but that's now all changed, and the case that confirms that now is in 1972, and that is British Railway Board and Harrington, which clearly confirms that if you are a trespasser you can actually claim compensation. Right, next point. So section 1, subsection 1A of the Occupiers Liability Act 1984 simply confirms that you can claim for compensation if you suffer injury either because of what the occupier did or did not do. So it involves actions and omissions. So do remember that particular point. Right, move on then. So now, as I said before in lesson, if you think about it, the law's being very generous in the first place to award compensation to a trespasser who gets injured on somebody else's land. However, there is a limit on what you can claim. The 1984 Act restricts compensation only to personal injury. So if you climb over somebody else's fence to burgle their property and you cut yourself because there's some wiring on the top of the fence, and you also accidentally drop your watch and it smashes and damages, then you can only claim compensation for the injuries, the personal injuries you sustained, and certainly not for the damaged or broken watch. So do remember that point. There is a restriction on what you can claim based as you being a trespasser. Right, what's the rationale behind that? As you might have guessed already, trespassers are not deserving really of any kind of compensation, but the law's generous enough at least to award them some compensation for personal injury, but not damage to property. Right, conditions then upon which a duty arises. This is very, very, very important. So Section 1, Subsection 3 of the Occupiers Liability Act 1984 simply identifies 3 circumstances where a claimant trespasser may be successful in claiming compensation. Now, the first one is they have to show that the defendant knew that they would come onto the property. So if council owns a piece of land and they're aware that children constantly come onto that land to either play on the grounds, then it's very clear that the defendant, occupier or landowner is aware that every now and again persons come onto the property. So that's the first thing that the claimant trespasser would have to prove. They would have to prove that the defendant was aware that they did come onto the property. Right. The next thing is to show that the defendant, the claimant rather, is in the property and also within the area of danger. So that's very important as well. So apart from the occupier knowing that somebody is there, they also have to be aware that there is potential danger for them to be injured. Right, how many minutes? 6 minutes, right, okay. Next point, the claimant trespasser would also have to prove that the defendant didn't offer any protection. So they're the 3 key things that you've got to remember under Section 1, Subsection 3 of the Occupiers Liability Act 1984. So do remember those points and make sure you apply those in any questions that you have. Right, Section 1, Subsection 4, that's mainly to do with the fact that the occupier has a duty of care to make sure that nobody gets injured, so have a quick look at that one. Now, the defendant, occupier or landowner will not be responsible if the danger is obvious to the claimant trespasser. So the case of Ratcliffe and McConnell in 1999 is a very clear case where a 19-year-old student climbed over a fence of his open-air swimming pool, dived into it, hitting his head on the ledge. The defendant occupier wouldn't be responsible because it's very obvious that by diving into shallow waters or diving into a swimming pool without taking care, there's a potential risk of you getting injured. Right, the timing of the incident, and this is quite an interesting case, and most of the cases that we go through surprisingly protect the defendant, occupier or landowner. So most claimant trespassers have not been very successful in claiming under the 1984 Act, because I think the whole idea is that if you're a trespasser, then you get what you deserve. So Donoghue and Folkestone Properties in 2003 is to do with where the defendant occupier was aware that persons would come onto the property and use or swim in the water. But this time, the timing of the claimant trespasser's actions was very unusual or not foreseeable. So he went late at night, in fact midnight, and he dived into the waters in the winter. So even though the defendant occupier knew that persons were using the waters, certainly they wouldn't expect anybody to use it at midnight, neither would they expect anybody to use it in the winter. So the claimant's claim in Donoghue and Folkestone did not succeed, mainly because of the timing of the actual incident. Right, next point is again a benefit to the defendant, occupier or landowner. The law doesn't expect you to spend an awful lot of money to protect your land, so long as you've done what is reasonable. So if you've got a piece of land and there's a pond on the land, then the key thing would be that you would have a fence around it if you can afford to do so. If you can't afford to have a fence, then clearly there'll be warning signs to suggest that persons are discouraged from diving into the waters. So the defendant occupier, under the case of Tomlinson and Congleton Borough Council in 2003, is not required to spend an awful lot of money. That doesn't mean they don't have to make sure the premises is safe, but they don't have to go the the extra step of spending money to keep it safe. Right, there are 3 points under Tomlinson and Congleton. You can have a quick look at those on the PowerPoint slides. If you've got any questions about those, then do let me know. So this next slide, Higgs and Foster in 2004, is to do with a case where the defendant occupier wasn't aware that the claimant would be on their property, and this is to do with a police officer who was carrying out surveillance and accidentally got injured and had to retire from the police force. Now, the actual landowner had no idea that the police man or person would be on the premises carrying out surveillance. So if you're a defendant landowner and you're not aware of the claimant's presence, if any injury happens to the claimant trespasser, then you would not be responsible. Right, next point is where the occupier is not aware of the danger. So again, Ryan and Asprey Water Park in 2004, do have a look at that case. It's fairly straightforward, but if the occupier isn't aware of the danger, then again they cannot be held responsible. Child trespassers, nearly to the end now, but child trespassers, the case of Keon and Coventry Healthcare Health Trust. Again, 11-year-old boy showing off, climbed up part of a building, fell and injured himself. Again, even though child trespassers are protected, in this particular instance, the child's behaviour was careless and reckless, and therefore the occupier landowner had no responsibility. And then you've got another case involving another 14-year-old in Baldacchino and West Withering in 2008. 14-year-old boy dived off a navigational beacon, suffered serious injuries. Claim failed again because the landowner didn't have to warn potential trespassers of obvious dangers. And on that note, that's the last case in the slides. So I know I've rushed through it, but based on what we've had to go through this morning, trying to sort out the live chat, which didn't go so well, at least we you know, if I need to, then I can create these little short clips to go through certain topics. So that's a quick summary. I think the key thing to remember is under the 1984 Act, the Occupiers Liability in 1984, it does protect trespassers, but they can only claim for personal injury and certainly not for damage to personal property. 3 things that need to be proven under Section 1.3. Do have a look at those 3 points. And as I say, I will eventually set you some work on this particular topic. Right, sorry about the rush, but thank you so much. And any problems, you can message me on Microsoft Teams. Thank you. Bye.